Thank you very much, Khaled. I'm very happy to have the opportunity to speak with you and all of our attendees today about the importance of being prepared for privacy breaches. So today I'm going to provide an overview of 3 basic issues for privacy breaches. I'm going to discuss why you and your business partners need to be prepared. Then I'm going to provide a high-level overview of how to be prepared. And then I'm going to run through the breach response reaction life cycle. Now, privacy breaches are nothing new. There's been privacy breaches ever since there's been personal information. In 1993, or it might have been 1994, when I was responsible for information security and privacy at a large multinational financial insurance organization, I had to deal with my very first privacy breach. And, well, it really wasn't an actual privacy breach, but it was perceived to be a breach by the public. A contracted shredding company was hauling away print materials that we'd used for our training with brokers and agents. And the papers contained a lot of made-up information for pretend insureds that they were using for the training. And they were using actual forms that would be used by the company. Now, the truck driver apparently did not shut the doors securely, and so while he was driving away from our facilities, all the papers flew out on the streets of the city as he drove through them in the very early hours of the morning. And he didn't realize this until he got to his destination on the opposite side of the city. So the folks going to work found papers containing what looked like real personal information all over the sidewalks and in the streets and in the gutters. And of course, our company's logo was printed at the top of each page. Now, some folks reported it to the local TVs and newspapers, and of course, they quickly reported this incident as involving real client information. Now, just consider, at this point in time, there were no legal requirements for breach response. And the breach was caused by a contracted third party. However, I and my organization had to deal with the impacts of the publicity and also respond to what was reported to be a breach of actual personal information, even when it wasn't. Now, talk about hundreds of lessons learned. I certainly learned a lot from that experience. Today, there are infinitely more types of technologies that access and process personal information, and infinitely more people who have access to personal information, and as a result, infinitely more ways in which breaches can occur. And the idiom, "you will be judged by the company you keep," is still appropriate today, especially when talking about privacy breaches and considering who the public, and often the law, sees as ultimately responsible for lack of safeguards that lead to breaches. Consider the St. Barnabas healthcare system in New Jersey. Now, they've had not one, but 2 significant privacy breaches within the span of just a little over a year. And of note is that each was a breach that occurred within their business partners. Ultimately, their patients viewed the hospital system as failing to properly ensure their patient information was safeguarded, regardless of whose hands it was in when the breach occurred. Now, these and hundreds of other recent examples should really highlight the need to ensure that not only your organization has effective safeguards and privacy breach prevention and response measures in place, but also to ensure all your business partners have them in place as well. Every organization that collects, processes, or stores personal information must address the issue of breach response. Now, think about it. Are your business partners effectively protecting the information you've entrusted to them? And will they respond appropriately in the event a privacy breach does occur? There are many breach response laws and regulations throughout the world. In the U.S., there are at least 49 U.S. state and territory breach notice laws. And it's worth pointing out that high-tech significantly expanded the types of personal information that is covered beyond those breach notice laws, most of which were limited to just a handful of information items. High-tech requires response notices if risk analysis following an incident shows that there's a likelihood that any of the 19 types of named personal information items have been accessed or used in an unauthorized manner. It's also increasingly common for an organization to contractually require their business partners to have breach prevention and response plans and practices in place. For example, any organization that processes credit card payments must have breach response plans in place as part of their PCI DSS contractual requirements to even be able to process those credit card transactions. Now, I've performed hundreds of information security and privacy audits, and most of the organizations I've reviewed did not have documented breach response plans. Even the smallest organization needs to document a plan of some kind for how to respond to breaches. Basically, every organization that does business needs to not only implement safeguards to prevent privacy breaches, but they also need to have documented privacy breach plans in place. Now, after all, there's no such thing as 100% security. So you need to be prepared for when those breaches will inevitably occur. For the next several slides, I'm going to describe at a high level how to get prepared for breach response. So first, define personal information. Has your organization done this? And is it documented? Do your personnel know and understand what is considered to be personal information? And then, do they know how to safeguard it appropriately? The definition of personal information will vary from organization to organization. There's simply not one universal definition for personal information. In the healthcare sector in the U.S., the Health Insurance Portability and Accountability Act, or you'll hear it referenced as HIPAA, defines personal information as protected health information, or PHI for short. Now, I'm going to show you those items in the next slide. Also in the U.S., in the financial space, there are various laws and regulations. The Gramm-Leach-Bliley Act defines personal information as non-public personal information, and it contains different items than the PHI items, along with some similar ones. Along with the numerous other state and federal regulations that define personal information in many different ways, you really need to know the laws, the regulations, and the contractual requirements that apply to your organization, and then take all those definitions and use the sum total of those data items as your organization's definition of personal information. And it's important to know that the definition of personal information is not static, and it could be a conglomeration of many different types of data items that reveal information about specific individuals or even groups of individuals. For example, I've been leading the NIST Smart Grid Privacy Group since June of 2009, and one of the issues we've identified is how energy usage and other information related to smart meters and the other smart grid components could point to specific individuals or households. Now, these are basically new types of personal information, or may be considered to be a type of personal information. The same goes for other new types of data, such as that from global positioning systems, and then there's the ever-expanding data that's not only posted to social media sites, but think about the information that's created from new analysis and data mining, and also the other types of insightful data that takes all that social media activity and creates information about individuals that can be incredibly revealing. New types of personal information that's not directly covered by laws and regulations, but still could have some tremendous privacy impacts upon people. And there's new identifiers that are being considered, such as those within the proposed U.S. National Strategy for Trusted Identities in Cyberspace, or what's known as NSTIC. The list could go on and on. Now, consider which of these may also apply to your organization, and then add them to whatever you have as your company's definition. And also, check with your business partners. How do they have personal information defined? Do they have it defined? Make sure that your business partner's definition falls within your organization's definition. Let's now look, just as an example, of all the many types of data items that are considered to be protected health information, or PHI, under the U.S. HIPAA regulation. Notice the catch-all item at the end of this list. Now, this is a gotcha item that too many organizations simply don't think about. For example, many hospitals now realize that they must include tattoos on their patients as a type of PHI item that would fall into this number 19 category. As mentioned earlier, there are many other laws and regulations in the U.S. and Canada, and now most other countries that have many different types of data items that are explicitly named as being personal information. A few years ago, I compared around 50 different laws and regulations worldwide, and of those, I documented right around 60 different specifically named items. Now, your organization and your business partners need to know what applies to your organization. It's a very important part of breach response to know what is considered as personal information. So now you need to know who collects, processes, stores, or accesses personal information, in addition to documenting how it's used. You should also have a position formally documented as being responsible for doing these activities and keeping an inventory of the personal information that you use up to date. If you don't know the uses for the personal information, it's going to be much harder to determine when a breach has occurred. You may have a breach as a result of misuse. For example, if you collect patient information in order to provide health care, but then use patient images or other unique information about them within your marketing activities without the patient's consent, that would not only be a type of breach for misuse, but also a violation of likely multiple laws, regulations, and contractual requirements. Earlier this year, I actually read an article that appeared in a widely circulated magazine that was describing how bill collectors should use social media to collect debt. The article even stated that, quote, perhaps the best part of the information you get on social media sites includes dates of birth, email addresses, mailing addresses, names of relatives, employers, and where they are located, and that it's all free. Well, you know, the authors were obviously not up on their data protection requirements and laws. Remember, just because you find some information online does not mean that you can use it for your business activities. So think, are any of your business departments doing this? I found several marketing areas in many different organizations that look online and use whatever they can find because they think that it's free and that it doesn't have any legal restrictions. This could lead not only to legal problems for your organization, but also create breach situations. And how about your business partners? Are your business partners misusing any of the personal information that you've entrusted to them to process or store? Have you outlined for them the purposes for which they can use the personal information you've entrusted to them and made it clear that they cannot use that personal information for any other purposes? There have been more than one contracted call centers that actually sold the personal information they receive from their clients to create additional revenues for themselves. So you really need to make sure that everyone involved with with the personal information your organization is responsible for is doing the right thing with it. Now, how can you know if a breach occurred if you don't even know where the personal information is located? This is so important. You need to locate all of the personal information as much as you can within the organization. And in the course of a business day, organizations collect personal information in many different ways. Some of this information is in the form of unstructured data, such as within email messages and Word documents. Be as comprehensive as possible in your identification of these personal information storage locations. And don't forget about those often overlooked storage areas where massive amounts of personal information could be hiding. Map out how the personal information flows throughout your organization. And there are many different types of automated tools that can help you to accomplish this. You need to have storage locations, including those mobile endpoints and employee-owned storage locations identified. These should include documenting the third parties to whom you've entrusted to store information for you. Ensure your third parties and business partners also establish their own inventories of personal information and that they keep it up to date. Where are they storing your information, and are they outsourcing any of the storage? You need to know that as well. You need to have documented data retention requirements as specified by the organizations that you do business with or for, and also as applicable to your own organization, such as HIPAA in the U.S. and by PIPEDA in Canada, and so on. Such retention requirements would be good to be incorporated into the personal information inventory that you've established. Also, you need to know what promises you've made regarding retention, such as within your posted website privacy policy. Do you know what your privacy policy says about retention? You need to comply with those types of statements as well. I found most employees within organizations have no clue what their own organization's privacy policy says, even when they would be the ones who should be responsible for supporting some of those privacy policy promises. So keep in mind that one of the most effective ways to prevent a breach is simply to not have the personal information if it's not necessary. So as soon as you no longer need to retain personal information to meet these requirements, effectively, securely, and irreversibly get rid of that personal information. The less you have, the less likely it is that it will be breached. Access to personal information should not be given beyond the purposes for which the information was collected. For example, if you did not collect personal information explicitly for doing marketing, then don't give your marketers access to it. The fewer folks that have access, the less opportunities for breaches to occur. You need to have safeguards implemented to restrict access to only those who have a business need to access the information for business purposes. Now, every business partner should do regular privacy impact assessments, often called PIAs, and other types of risk assessments, and then implement effective safeguards to appropriately mitigate the identified risks, following their own documented policies and procedures. One really effective type of safeguard for preventing breaches is encrypting personal information using strong encryption. Encryption options today are comparatively easy to use and often inexpensive, especially considering the costs of the breaches that they are preventing. Encryption is also a fabulous security tool, so use it whenever you can. Also, de-identifying information can also be effective. Khaled will provide more information about this when he talks. Okay, now that you've done all those very important activities, you can now establish an effective breach response plan. Too many organizations jump right into the breach response plan at this point, documenting the plan itself. However, how can your plan be effective if you don't know the personal information you have or where it's at or how it's used? It really wouldn't be effective. Do those important steps earlier and then document your breach plan. Every organization and each of their business partners needs to have a documented plan in place for how to identify and then respond to a breach. Now, this includes documenting how and when your organization will be notified if a breach involves your information. Simply writing down on a piece of paper, we'll call Joe as our breach response plan, does not qualify as an acceptable breach response plan. And I actually had an organization tell me this during one of my audits of their security and privacy programs. There's a wide range of documentation that needs to be in place to help ensure that you can react to a breach effectively, efficiently, and consistently. And we could talk probably for a week about what needs to be done once we get to this point of our breach response activities. And perhaps that would be another good area to drill deep into within some other webinar. But for now, you need to ensure that you've used all the information you've gathered so far to create documented policies and procedures, to identify and assign team members and document their responsibilities within the breach response activities, that you've created processes for the breach response communications and how you're going to create the reports and how you're going to distribute them. You need to make sure that the actions have occurred and that different types of procedures exist to determine the likelihood of a privacy breach based upon whether you can tell if inappropriate actions have occurred and determining for sure whether or not the data was encrypted or the hard copy materials that might have been involved were appropriately disposed of. You need to have a clearly documented breach notice protocol if you determine a breach truly did occur. And then always continue to follow up after you've done the immediate breach response so you can catch any downstream impacts of delayed activities that result from the breach. Smart criminals know to wait 6 months, a year, and I've even heard of a case or two where they've waited a couple of years before using personal information because they know most folks and most organizations don't do this step of breach response well, if at all, this follow-up to make sure that nothing bad will continue to happen. Now, every business partner needs to communicate information about their information security and privacy policies and procedures and how to do the associated activities that I described in the previous slides. And they need to do this through regular training and ongoing awareness communications. These actions need to be supported with the appropriate technology tools and appropriate control processes. This is another topic that we could really drill deeply into and cover for a good day. Just all the different communication paths and methods that need to occur during a breach response. Make sure your business partners are doing all of this as well as your own organizations. Now, some organizations are really leery of providing training to their business partners, and I've heard some lawyers even advise against it because of liability concerns. However, it just seems to me that it would be better to provide your business partners with training about how to protect information and training about what to do in the event of a breach, and then prevent those breaches as a result of having more informed business partners than it is to keep them in the dark and not give them this training and dramatically increase the likelihood that they would do something silly or dumb from lack of knowledge and training. And then you'd have to pay potentially millions of dollars for their breaches. If you don't want to provide the training to them yourself, then certainly you can require that they get such training within the contracts that you have with them. So now you've created your breach response plan. Well, are you ready to use it? Do you know if your breach response plan covers everything you need for it to cover? You need to run it through with a good test with your team members, and you need to find out how well you would be able to truly react to a breach by following your plan. Now, over the years, I've created many different types of breach scenarios, and I've provided them as tabletop case studies, activities in my classes. And I've included a wide variety of situations and details from actual breaches so that those involved would understand that the scenarios really are possible and indeed really actually happen. An important consideration when responding to a breach is determining whether or not you're going to need to give notice to the individuals whose personal information is involved. Now, this should involve determining whether encryption was used, or if the data was de-identified, or if appropriate disposal methods were used. Many, but not all, breach notice laws do not require notice if encryption is used. As an example, under high-tech, a breach of PHI that is encrypted using a minimum NIST encryption method does not require notification to the associated individuals. However, if you cannot prove this, then notice would be necessary. This is one more reason why doing all that prep work that I covered earlier is so important. You need to have your encryption use documented. Likewise, if a breach involves personal information on digital storage media and you can show the data had been destroyed consistent with NIST SP 800-88 requirements, and that's the specific standard, again, that high-tech references, or you could show that print information had been irreversibly destroyed following that same SP 800-88 standard, then you would not need to provide notice to the individuals whose information might have been on those storage devices or on that shredded up material. Again, you need to have this documented. You also need to determine the likelihood that the breach would pose a significant risk of financial, reputational, or other harm to an individual. This should be done following your documented procedures to determine this based upon the personal information items involved, the safeguards in place, and the other associated situation details. See, here you would use all that information about the definition of personal information and the inventory of where it's located, who has access to it, and how it's used within this assessment. You need to also take into consideration the situations that would lessen the likelihood, such as if the personal information was unintentionally acquired by a worker in a different department, or if it was disclosed in such a way that you could document it was unlikely that the personal information could have been accessed or used. This risk assessment and likelihood determination is a very important aspect of breach response, and it doesn't get done often enough. It just doesn't get enough thoughtful attention in many cases. I've seen too many organizations simply leave it up to the legal office to make the call. However, everyone with responsibilities for that personal information need to be involved so you can get a good determination with all those who know the most about the personal information and who handle it the most. You need to make sure to include business partners as appropriate as well, and also ensure that they have good plans in place. If unauthorized access is likely, then you need to work with all appropriate parties, such as the PR area, the privacy officer, the information security officer, and certainly the law office, to give notice in the most efficient and effective way, or maybe more than one way, that's possible for the situation. Then you need to take steps to ensure that you don't have such a breach occur again, if at all possible. Now, I know I've covered a lot of ground in the past few minutes and an awfully lot of topics, and there's so much more that I could have gone into more depth and detail and discussion about. Here's my contact information. If you'd like to contact me offline after we're finished today, or if you want to ask some questions at the end of the webinar, I'll be happy to take them as well. But for now, I want to turn it over to Khaled to discuss some of the technical aspects involved with the breach response activities and also with personal information in general.
Thank you very much, Rebecca. So I'll focus on one aspect of the breach preparation and response protocol that Rebecca has described, and this mainly has to do with the identifiability of information, how to classify information according to identifiability. This issue is not discussed very often in the context of breaches, and as I hope to illustrate, it's an important issue that can have a big impact on whether you notify the breach or not, whether an incident is considered a breach or not. So first of all, I just want to make clear that re-identification risk falls on a spectrum. Most privacy laws treat it as a binary construct by talking about identifiable or non-identifiable information or data. But in fact, it falls on a spectrum. If you consider it as a probability, then it's a spectrum from 0 to 1. And this is consistent to some extent with some of the privacy regulations. For example, in HIPAA, the expert standard in HIPAA or expert certification standard in HIPAA talks about ensuring that the risk of identification is very low. And in PHIPAA in Ontario, for example, there's a reasonableness standard that it's not reasonable for the data to be identified. When you have a spectrum like this, the way you'd make these definitions consistent with the spectrum is by defining a threshold, and if the risk of identification is above the threshold, then it's identifiable information. If it's below the threshold, then it's not identifiable information. A lot of the work that we've done has involved measuring identifiability or the risk of identification. So even though it falls on a spectrum, it can be measured very precisely and very objectively. The measurement of identifiability has been an ongoing topic for more than 20 years in the statistical disclosure control world. For example, with the Census Bureau in the US, Statistics Canada in Canada, it's an issue that they've had to deal with because they've been releasing census data for quite a long time. So it's not a new topic. It's something that there's a lot of experience with measuring the identifiability. An important point to keep in mind is that the appropriate, from risk management perspective, the appropriate amount of identifiability will be context dependent. And I'll talk a little bit about that momentarily, because it has an impact on how you deal with it with a breach when it occurs. So when you consider identifiability and access to information within your organization, you have to keep in mind that a large percentage of data breaches are due to insiders, depending on which survey or which analysis you look at. Between 25 to 50% in some cases, or in some studies, of breaches are due to insiders. Now, these may be malicious or accidental. A lot of them are accidental, but still a significant percentage of those insider caused breaches are malicious. And because there's a large number of insider caused breaches, ensuring that managing how the information is handled within the organization is very important. So if you're able to access, so able to classify data by its identifiability, then this allows you or allows the organization to manage the risk by instituting appropriate data handling practices um, that are commensurate with the risk and responding appropriately to a breach. Um, so when you classify your data holdings as by their identifiability, it's not the only thing, of course, you need to that you use to classify your data holdings. You look at sensitivity, confidentiality, and value to the organization, which are more common. But in the context of a breach, classifying your data holdings by identifiability is very important. If a breach involves identifiable information, then of course it has to, if there's a breach notification law in your jurisdiction, then it has to be, you have to notify, whether it's notifying the individuals affected or notifying the regulator and or the media. And if the data can credibly be claimed to be de-identified, then there is no requirement for breach notification. So this is a very important distinction. So being able to identify all your data holdings and classify them as identifiable or not identifiable, or identifying the risk of identification or measuring the risk of identification and determining whether it's high or low, and then making an assessment based on that measurement, whether you consider it identifiable or not, is important as part of the preparation um, or being ready for a potential breach. So as I mentioned, breaches of identifiable data need to be notified. I'll make a contrast here with encryption. Now encryption, of course, if the data is encrypted, then there is no requirement to notify. In certain jurisdictions, you have the encryption exemption. However, it does depend on the type of breach you're talking about. So, for example, if you lose a disk drive, or the breach is a loss of a disk drive or a thumb drive, a USB stick with data on it that is encrypted, then the exemption would kick in. However, if the breach is due to an active attack on a database, for example, through an SQL injection attack on a database, then the attacker would get access to raw data, even if the database itself is encrypted, because it's an active attack through an application. The raw data would still be extractable that way. The encryption would not protect it. So one has to consider the method of the breach to determine whether encryption has protected the data or not. So if it's a SQL injection attack that has resulted in a loss of data, for example, then if the data in the database is credibly claimed to be de-identified, then it's not a breach. But if the data in the database is identifiable, then this would be considered a breach. So one has to consider the identifiability in conjunction with the use of encryption when deciding whether a breach falls under an exemption or needs to be notified or not. Just the use of encryption by itself will depend. I mean, its impact on the requirement to notify will depend on how the data was lost. So when we look at identifiability, as I mentioned before, it's context dependent. And we look at a number of different factors, 4 of them to be exact. The first one is, of course, the amount of de-identification that's done to the data. And the second is what we call the mitigating controls, which are the security and privacy practices that exist to handle and manage the data within the organization, or when it's if it's disclosed. The motives and capacity of the person who has the data to re-identify it. And then there's an invasion of privacy test, which looks at the sensitivity of the data and the potential harm that occurs to the patients if there is an inappropriate disclosure. The key point here is that the amount of de-identification you apply to the data is really one factor that impacts your risk of re-identification. So the same data set with the same amount of physical de-identification done to it in 2 different contexts may have a different level of risk. And the 2 examples here, or the 2 scenarios to consider, are use the same data set when it's used within the organization, or the same information when it's used within the organization, and then when it's or if it's breached, if it's lost or stolen, um, then you effectively have to consider it as public data because you have no control over it, and you don't know if the whoever got the information is going to post it on the internet or make it broadly available. So you have to consider it public data. So the same data set exists or can exist in two states: your internal, when it's internal to the organization before a breach, and when it's external to the organization after a breach, when it's public data. Because the identifiability is context dependent, uh, the identifiability for that data set will vary between those two scenarios. So, and one good reason why this is the case, for example, is when you do a holistic or a complete risk assessment on a data set, you'd want to look at the likelihood that the data holder will attempt a re-identification on the data. And if the data is internal to the organization, then you have controls in place that will, for example, prohibit staff or departments from linking the data with another data that's internal to the organization, so that you are compliant with the conditions upon which you obtain the data. But when the data is external, the probability of someone trying to re-identify the data is much higher because you have no control on it. So when doing an evaluation of identifiability of the data set, you have to evaluate what the risk would be if it's public data, not just if it's internal data. If it's internal data, you evaluate identifiability, and that determines how you handle the data internally and what controls you have in terms of staff access and which type of staff would have the information. But if a breach occurs, that same data set falls in a different context, and its risk of identification may change significantly. So you have to do both of these assessments in advance when evaluating the identifiability of the data. For example, if a data set has a high risk of identification in the public mode or public scenario, then you would probably want to protect it more, and then have a breach response or protocol that is commensurate with the high risk when the data is released. However, if you do a risk assessment and if the data in the public domain has a low risk of identification, then your response protocol will be quite different. So I'll leave it at that. I think I just wanted to get the key point out that identifiability is context dependent, and you'd have to consider the internal and external risks or identification risks to the data when deciding whether it's personal information or not, and in preparing your response to a potential breach. And with that, I will then switch to the questions, and you should be able to see the text box now on your screen. And if you can start asking your questions right away, and then we'll pick them up and answer them. I think Rebecca will read the questions. So while we're waiting for questions to come in, Rebecca, I wanted to ask you one question about the Graham-Leach-Bliley Act. You said something about person identifying information being non-public information. I was just wondering if you can clarify that a little bit.
Oh, sure. I guess my point I was trying to make is that within different laws and regulations, they have different terms that they use for the personal information that they cover. In the Graham-Leach-Bliley Act, they call it non-public personal information. Sometimes that's written as NPI, and sometimes you see it as NPPI. Now, in HIPAA, the data items that they cover is called Protected Health Information, or PHI. And so I guess my point was that there are many different sets of personal information items out there that are defined very differently within different regulations and within different industries and so on. So it's important that you know all of the different laws and regulations that apply. Certainly if you look at the U.S. state and territory laws that have to do with breach notice, you'll find that they all are a little bit different from each other with regard to how they define the personal information items that they consider whenever there's a breach and what you have to know about. Some include full Social Security numbers, some include just portions of the Social Security number, and so on. So there's just no one standard for what personal information is throughout the world. Does that clarify? Or
yeah, so if one was to adopt the strictest standard, which state law or federal law should they follow?
Well, again, different laws have varying degrees of strictness based upon the activity. If you want to look at, for breach notice specifically, probably most comprehensive law so far is high-tech, because it goes into some pretty good detail with regard to what has to be done whenever information is inappropriately used or authorized. Now, it also has a much larger number of items that are considered whenever you're trying to determine whether or not a breach occurred. If you're looking at some of the other laws, you might only have a handful of 4 or 5 different items to consider as a breach. But if you're looking at high-tech, it includes those 19 items, and the catch-all 19th item kind of opens it up to basically anything that can point to a specific individual. So yeah, it with regard to looking at all the different laws that apply, to apply the safeguards and the actions, I would say take the most stringent of them, and you'll be doing good. With regard to defining personal information, I'd say you need to consider all of the data items within all of them and kind of use the sum total of them. We do have a couple of questions here now. We have one, are you aware of any breaches of smart grid data? Ooh, that's a good question. Khaled, I'll answer this first, if you don't mind, and I'll go ahead and pass it to you if you'd like to add to that. Currently, the smart grid is pretty new, and there are many different places in which smart grid data is being stored. Now, some of that smart grid data, or what's thought of as smart grid data, is not under the direct control of utilities, and oftentimes consumers are putting the data from their smart meters and within their home networks out into some other third party's care. I'm not aware of any explicitly reported breaches of data that would be considered as smart grid data, but that doesn't mean that there haven't been any breaches that occur. As the smart grid continues to evolve, I think we'll see more instances of at least reports of potential breaches, but I can't name any off the top of my head. Khaled, do you have anything you'd like to add to that? Or
I would extend the question a little bit and maybe ask about data on the cloud as well. There's a movement towards use of the cloud. So I'll turn it back to you and ask you, do you know of any breaches of data that's been on the cloud?
With regard to an explicit cloud service, I've not seen any reported that have said that they've been breaches in the cloud, but that said, anytime you're using an organization that's storing data on the internet and managing data for some third parties, they have to have the same level of security and, in fact, additional security to protect against the type of environment that they've created than any other type of organization. So certainly they're going to have some unique risks that traditional businesses have not had. I imagine there have been breaches, but have I seen any published breaches? Again, off the top of my head, I can't think of any. I think what's important to keep in mind is that there's probably a lot of breaches that occur out there that never get publicized. Now, that said, that doesn't mean that they have not been reported to the individuals who were impacted, because I do know of several organizations who have had breaches, and they reported them according to laws that applied, but yet they did not have to publicize them, and they did not get publicized. So there's a lot more breaches that occur out there than we ever see reported in the news. We have another question. Is it possible to apply the same data management and breach response planning for data that is not considered personal information, where's it at, but that is considered proprietary information and potentially intellectual property, such as far as it's being shared through execution of a data sharing agreement of the sort? If so, are there similar laws that would apply to this data? So certainly security standards and best practices should apply to any type of data. And if you're talking about information that's not personal information, but yet it should be protected because it's sensitive, it might be mission critical, it might be intellectual property, the same types of safeguards need to be in place. And certainly you do need to have processes in place where you can identify if that information has been accessed in inappropriate ways. So the same concepts would be able to be applied. Now, with regard to the laws, you have your intellectual property laws that would be probably come into play in addition to, trying to think, for instance, such as in Sarbanes-Oxley, you have the need to have controls that are implemented to appropriately protect the data. And not all of that data is going to be personal information, but certainly it will be of a proprietary and confidential nature. And so you need to ensure that those types of safeguards and requirements are followed. Khaled, do you have anything to add to that? Or
no, I think this is good. This is good. So we have only a couple of minutes left. I just wanted to ask you one last question, and it has to do with business associates. And you mentioned that the covered entities or data custodians have to take responsibility to some extent when they give data to their business associates. But if there's a breach at a business associate, say I'm a data custodian and I give data to a business associate and there's a breach at their site, to what extent should I be involved, or what would your advice be in terms of getting involved in the response and handling of that breach?
Oh, that's a great question, and it's very important. If they have a breach that involves the data that you've entrusted to them, you need to be very closely involved. If you're in the healthcare space in the U.S., high-tech actually requires that any type of notification to the impacted individuals come through the covered entity. So the business associate needs to contact the covered entity as soon as possible and then coordinate the breach response activities with them, and then the covered entity would be the one to make the notification unless some other arrangement has been made with regard to legal contract requirements and so on. But, you know, when you think about it, it really makes sense. Like if I go to a doctor or if I go to my CPA and I give my CPA my information, and then unbeknownst to me, the CPA is outsourcing the storage of it somewhere or some sort of backup processing or some other activity, and that outsourced entity has a breach, who should contact me? You know, if it were you, who would you want to have contact? Well, if I had some organization that I've never heard of before contact me and say that my information has been breached that I gave to my accountant, I'm gonna wonder what's up. I'm gonna think, is this somebody who's trying to do some sort of social engineering attack or some sort of phishing attack? And also, it makes me wonder, well, why was my CPA sharing my information to some third party? You know, what's going on here? So in order to have a good management of that relationship between the primary entity and their customers or their clients or patients, that communication really does need to come from the covered entity or the primary organization that has the relationship. Now, of course, that's a general rule of thumb. With each situation, you're going to have to look at the unique issues involved, and you might have differences depending upon the type of breach and the information that has been breached. But in general, you usually want the entity that collected the information from the individual to begin with to be the one having the primary relationship and communication path with the individual, since the individual's saying, hey, you're the person I gave the information to, so I'm holding you ultimately responsible, even if you did hand it off to somebody else to take care of.
Great, thank you so much.